I want you to picture something. It's a Tuesday morning in September. The kind of morning where the light comes in through the courthouse windows at a low angle and cuts the room in half, one side bright, one side shadow. I'm seated at the bench. I've been a judge for 19 years. I've presided over murders, kidnappings, racketeering, child predators. I have seen men weep. I have seen men laugh at their own sentencing. I have seen defendants collapse on the courtroom floor. I thought I had seen everything. I was wrong, because on this particular Tuesday morning, a man is standing at the defense table and he is screaming. Not arguing, not protesting, screaming. He has just torn a piece of paper in half and thrown it in the direction of the prosecution. My bailiff is already moving. The court reporter has stopped typing. Every person in that gallery is holding their breath. And then across the aisle, a woman stands up. She is small. She is probably 62 years old. She is wearing a navy blue cardigan, and she is the mother of the boy this man killed. She doesn't look at me. She looks directly at him, this man who is red-faced and shaking and convinced that no court on earth has authority over him. And in a voice so quiet that I had to lean forward to hear it, she says 7 words. I forgive you. I pray you find peace. The room went completely silent. Even him, especially him. I have been asked many times in my career what the most surprising moment I ever witnessed from the bench was. People expect me to say a surprise acquittal, a last-minute confession, a witness breaking down. No, it was that moment, that woman, those 7 words. This is the story of how we got there. Marcus Allen Drell was born in 1974 in a mid-sized city in the American Southeast. The third of 4 children. His father worked at a machine parts warehouse. His mother worked part-time at a daycare. By all early accounts, a completely unremarkable childhood. Average grades, a few minor school suspensions, nothing that would signal what was coming. He enlisted in the Army at 19. Served 2 years before receiving a general discharge. Not dishonorable, but not clean either. The records from that period are sealed, but people who served with him described a man who had a very specific and very serious problem with authority. Not just disagreement with authority, a visceral reaction to it, to uniforms, to rank, to anyone telling him what to do and expecting compliance without debate. After the discharge, he drifted. Alabama, Tennessee, Georgia. Worked construction jobs when he wanted to, lived in his truck when he didn't, got married in 2001, divorced by 2004. One daughter he would see maybe once a year. And somewhere in those drifting years, somewhere between a truck stop in Chattanooga and a rented room in rural Georgia, Marcus Drell found the internet. Now I want to pause here because I know some of you watching this have seen this pattern before. You've seen these court cam videos. You've seen the guys who walk into traffic courts and tell the clerk they are a sovereign national and do not recognize the jurisdiction of the court. You've smiled at it, maybe laughed. Because on a traffic ticket, it's almost comedic. The judge rolls their eyes, the bailiff tries not to grin, the fine gets doubled. But I need you to understand something. The sovereign citizen ideology, and make no mistake, it is an ideology. It is a movement with a pipeline, with recruiters, with online academies that charge $300 for a PDF. That ideology does not stay in traffic court. It grows, it metastasizes. It gives a man who already has a problem with authority a theological framework for that problem. It tells him, you are not wrong to resist. You are, in fact, legally correct to resist. The entire system is a fraud. You are the only sovereign. No judge, no law, no jury has power over you unless you consent. Marcus Drell consumed this material like oxygen. By 2008, he had accumulated a binder. Not a folder, a binder. Laminated tabs, color-coded sections. Copies of pseudo-legal documents he had downloaded from websites with names like nationalfreedomsovereign.net and commonlawrepublic.org. He had paperwork arguing that his birth certificate was a maritime bond traded on the New York Stock Exchange. He had a self-issued sovereign identification card that he carried alongside. And I want you to appreciate the irony here, a valid state driver's license. He filed documents with the county recorder's office declaring himself a non-resident alien to the federal United States and a sovereign flesh and blood man operating under common law and not statutory law. The clerk who received those filings told investigators later that she thought it was a prank. She stamped them anyway because that is what you do and filed them in a box. The county sent him a letter explaining politely that the filings had no legal effect. Marcus wrote back a 31-page response citing the Uniform Commercial Code, the Magna Carta, Yes, the Magna Carta, written in 1215, and something he called the original 13th Amendment. He signed it, Marcus Allen, Drell, a sovereign man, all rights reserved, without prejudice, UCC 1-308. The county did not respond. In their experience and in mine, you do not respond. Not because you are dismissing the person, but because responding validates the framework. It implies that their pseudo-legal documents exist in a universe where real law must answer to them. They do not. But here is where Marcus Drell was different from the man ranting in traffic court. He wasn't just filing paperwork. He was building toward something. He was, in the years between 2008 and 2015, establishing what he considered to be a sovereign land claim on a 14-acre property in rural Georgia that he did not own. He had moved onto the property, which belonged to a land trust managed by a family named Whitfield, constructed a structure on it, run his own utilities, and declared it a sovereign commonwealth exempt from state and local jurisdiction. The Whitfields tried twice to remove him through civil process. Both times, Drell appeared in court as a pro se defendant, meaning he represented himself and delivered what he called jurisdictional challenges. He argued the court had no standing to hear the case. He argued the judge had no authority over a sovereign man. He argued that the Whitfield's deed was a fraudulent colorable title and that the land reverted to him under natural law. Both judges, I have read those transcripts, handled it with patience and clarity. They explained the law. They ruled against him. They issued orders. Marcus Drell did not comply. In the spring of 2016, the Whitfield family sent their son, Caleb, out to the property to document the structure for an updated civil complaint. Caleb Whitfield was 24 years old. He was a second-year accounting student. He had, by all accounts, a remarkable gift for making people laugh. His mother, Diane Whitfield, would later tell me, in the quietest voice I have ever heard in a courtroom, that Caleb used to call her every Sunday night, no matter what, just to check in. That Sunday, he didn't call. He never called again. The Lowndes County Sheriff's Office found Caleb Whitfield's truck on the property road at approximately 6:15 p.m. Caleb was inside. He had been shot twice. The medical examiner would later determine he died within minutes. Marcus Drell was found 2 miles away on foot, still carrying the firearm. He did not resist arrest. He did not run. He simply looked at the deputies and said, with what witnesses described as complete calm, "You have no jurisdiction over me. I am a sovereign man. I acted in defense of my land under common law. This matter is not subject to your courts." He said it like he was explaining something obvious to a child. He said it like he had been waiting to say it. That was the moment I realized this case was going to be unlike anything I had seen in 19 years on the bench. I just didn't know yet that the most stunning moment wouldn't come from him. Let me tell you what a first-degree murder trial looks like before it begins. There is a machinery to it, invisible to the public, but every attorney in that room feels it. Weeks of pretrial motions, evidence rulings, jury selection, which in a case like this, with a victim whose family is known in the community, can take 3 days alone. By the time that jury sits down in those 14 seats and the bailiff calls the room to order, every lawyer at every table has been working toward this moment for months. They know the exhibits. They know the witnesses. They know their arguments so well they could deliver them in their sleep. That machinery depends on order, on procedure, on the understanding that everyone in the room, prosecution, defense, gallery, is operating inside the same set of rules. Marcus Drell had a different understanding. It started before I even sat down. I was told by my clerk, during the final pretrial conference, the morning of day one, that the defendant had submitted a handwritten motion overnight. Not typed, handwritten, in red ink, on what appeared to be regular notebook paper folded into thirds like a letter. The motion was titled, "Notice of Jurisdictional Challenge and Revocation of All Presumed Consent in the Matter of the Sovereign Man Marcus Allen. Drell versus the State Fiction." I read it twice. Then I set it down. My clerk looked at me and said, "Should I file it?" I said, "Log it, don't file it. It's not a motion, it's a declaration." There's a difference. A motion asks the court to do something. A declaration simply announces a position. Courts are not required to respond to declarations. Marcus Drell did not know this distinction, or he didn't care. When I entered the courtroom and took the bench, the public defender assigned to Drell, a capable attorney named Gerald Foss, 12 years of criminal defense experience, was already standing. His expression told me everything. "Your Honor," he said, Before we proceed, I need to inform the court that my client has, as of this morning, formally discharged me as his counsel and intends to represent himself in these proceedings. I looked at Drell. He was sitting with his arms crossed, wearing what appeared to be a hand-sewn lapel pin that read, "Sovereign Freeman, no consent." "Mr. Drell," I said, "is that accurate?" He looked at me levelly. "I do not recognize the name Marcus Drell as representing my person. That is a corporate fiction created by the state at my birth. I am Marcus Allen, a sovereign flesh and blood man, and I am here today in my own proper person to challenge the jurisdiction of this court before any further proceedings take place." The gallery made a sound. Not quite a gasp, more like the collective intake of breath before one. I have heard this before. Every judge who has dealt with a sovereign citizen case has heard this before. The name challenge, the flesh and blood man. The jurisdiction argument deployed as an opening move, like a chess gambit they've rehearsed 100 times in their truck or their kitchen. I did not raise my voice. I never raise my voice. "Mr. Drell," I said, "this court will address you as Marcus Drell, which is the name on the charging documents, the name on your birth certificate, and the name recognized by every legal instrument connected to this proceeding. Your challenge to jurisdiction is noted for the record and is denied. This court has subject matter jurisdiction over the offense charged and personal jurisdiction over you as the named defendant. We will proceed." He opened his mouth. "We will proceed," I said again, quietly. The way you say something when you want the other person to understand that the statement is complete. He closed his mouth. Gerald Foss was formally relieved. I appointed him as standby counsel, meaning he would sit at the defense table, available to advise Drell but would not speak for him. Drell objected to this arrangement. I overruled him. Foss sat down with the expression of a man boarding a flight he knows is going to be turbulent. Now I want to stop here and explain something important to anyone watching who hasn't seen a pro-se defendant in a serious felony trial before. The Sixth Amendment guarantees a defendant the right to represent themselves. The Supreme Court confirmed this in Ferretta v. California in 1975. It is an absolute right. A judge cannot force an attorney on a competent defendant who knowingly waives counsel. What the court can do is ensure the defendant understands the consequences of that choice, which I did, on the record, at length, before the jury was ever brought in. I asked Drell directly, "Do you understand that by representing yourself, you will be held to the same procedural and evidentiary standards as a licensed attorney?" He said, "I operate under common law. Your procedural rules do not apply to my person." I said, "They apply to everyone who stands in this courtroom. Do you understand the question I asked?" He said, "I understand that you believe they apply." I said, "That will be sufficient. Your waiver is noted." It wasn't sufficient, but it was all I was going to get. The prosecution's opening statement was clean and precise. Assistant District Attorney Sandra Voss had tried 11 murder cases. She knew exactly what a jury needed to hear in the first 12 minutes. The facts, the timeline, the human cost. She talked about Caleb Whitfield. She showed the jury a photograph, the kind that gets introduced into evidence in every homicide trial, the one that exists to make the jury remember that this case has a face attached to it. I watched the jury, I watched Drell. He was writing something, not notes. He was writing on a yellow legal pad in large block letters. He was preparing. Ada Voss finished. The room was quiet and heavy in the way it gets when opening statements go well, when 12 people have just been given a frame and they're settling it into place in their minds. Then it was Drell's turn. He stood up. He did not address the jury. He turned and faced me. "Before I make any statement," he said, "I am formally submitting into evidence this court's lack of jurisdiction over my sovereign person and presenting a common law counterclaim against the state of Georgia, a corporate entity, for unlawful detention and deprivation of liberty." He produced a document from his binder. Multi-page, red ink again. Notarized, and I use that term loosely, because the notary stamp on it was one he had apparently self-administered, listing himself as a notary public of the Republic with no state commission number. He walked it toward my bench. My bailiff stepped forward. "Sir," the bailiff said, "please remain at the defense table." Drell stopped, looked at the bailiff, then at me. "I am presenting lawful evidence to the court," he said. "You are presenting a document to me during your opening statement," I said. "That is not how evidence is introduced. Return to the defense table. This court does not have the authority to, Mr. Drell." My voice was level, even. "I want you to understand, calm is the weapon. Calm is the only thing that works in this situation because the sovereign citizen framework feeds on conflict. It needs the judge to lose composure. It needs the system to crack. The moment you raise your voice, you have handed them exactly what they want. Return to the defense table. This is your first warning. He stood there for 4 full seconds. I counted. Then he went back. He sat down, put the document back in his binder, and looked at me with an expression I can only describe as patient contempt. Like a man who believed he was watching someone make a mistake they didn't yet understand they were making. 22 minutes into the trial. We hadn't even started yet. Day 1 of trial continued. And I want to be precise about the timeline here because the speed at which this unraveled matters. From the moment the jury was seated to the moment I issued the first formal contempt citation, it was 47 minutes. In 19 years on the bench, I had never reached a contempt citation that fast. Not once. Here is how it happened. Ada Voss called her first witness, Deputy Aaron Marsh, one of the 2 Lowndes County Sheriff's deputies who had responded to the scene and made the arrest. Straightforward witness. Foundational testimony. His job was simply to establish the chain of custody from the crime scene to the arrest. 15 minutes, maybe 20. Clean, procedural, unremarkable. He made it 6 minutes. Deputy Marsh had just begun describing the moment he located Drell on the property road, calm, on foot, firearms still on his person, when Drell stood up. Not to object. A proper legal objection would have been, "Objection, Your Honor, hearsay," or "Objection, foundation." Even a pro-se defendant who has done minimal research knows the word objection. Drell did not say objection. He said, "I am formally revoking consent to these proceedings." The room went still. Deputy Marsh stopped mid-sentence. "Mr. Drell," I said, "sit down. I am invoking my right as a sovereign man to dissolve this court's presumed jurisdiction over my down, over my flesh and blood person, and I am placing on the record that any further testimony given in this courtroom is given under duress and coercion, and bailiff." The bailiff took 1 step toward the defense table. That step, just 1 step, was enough. Drell sat. But he kept talking. Quieter now, but still talking, still narrating into the record, still building his imaginary countercase in real time while Deputy Marsh sat in the witness box with the expression of a man who had been told this might happen but had not quite believed it. I turned to the jury. "Ladies and gentlemen," I said, "you are instructed to disregard the defendant's outburst. Witness testimony is governed by the rules of evidence. Comments made by the defendant outside of proper procedure carry no legal weight in this proceeding. We will continue." I looked at Drell. "Mr. Drell, you will have the opportunity to cross-examine this witness when the prosecution has finished its direct examination. That is the procedure. You will follow it or you will be removed from this courtroom. Am I clear?" He looked at me, that same patient contempt. "I don't recognize your authority to—" "That is your second warning. 1 more and we are done for today." He didn't respond, but he stopped talking. Deputy Marsh finished his direct examination without further interruption. 40 minutes of clean, methodical testimony. The firearm. The defendant's location. The exact words Drell had spoken upon arrest. "You have no jurisdiction over me. I am a sovereign man." The deputy repeated them to the jury in the flat, factual tone of someone who has read them off an incident report many times. No drama added, no drama needed. Then Ada Voss said, "No further questions, Your Honor." And I said, "Mr. Drell, you may cross-examine." Drell stood up, straightened his jacket, picked up a document from his binder, and walked not toward the witness, but toward the evidence table where the prosecution's exhibits were logged and stickered and arranged in numerical order. "Mr. Drell," I said, "the witness is in that direction." He turned. "I am submitting a counter-exhibit." "You are not submitting anything at this moment. You are cross-examining a witness. Please face the witness." "This document supersedes the prosecution's, Mr. Drell. Face the witness." He faced the witness. Deputy Marsh watched all of this with the professional stillness of a man trained to remain calm in volatile situations. Drell's cross-examination lasted 11 minutes. It was not a cross-examination in any legal sense. It was a series of statements, delivered as questions, designed to establish, on the record, that Deputy Marsh was an agent of a corporate state fiction, that his badge represented maritime admiralty jurisdiction, and that his testimony was therefore legally void under common law. Deputy Marsh answered every single one of them with the same 4 words. "That's not correct, sir." Every single one. The jury had moved from confusion to something I can only describe as exhausted fascination. Like people watching a car drive the wrong way down a highway, unable to look away and unable to understand how it was still moving. Then Drell turned to Ada Voss and said, Your co-conspirator, the fictional state actor posing as a prosecutor. That was the moment. Mr. Drell, my voice dropped half a register. Sit down, now. Has submitted fraudulent evidence in collusion with this court. This court finds the defendant in contempt. I said it the way you say something that has been a long time coming. Quietly, completely. Bailiff, the defendant will be seated. Mr. Drell, you have just earned a $500 fine, which will be added to the record. One more outburst of this nature, and I will remove you from this courtroom, and you will watch the remainder of your trial on a closed-circuit monitor from a holding room. Do you understand what I just said to you? Silence. The room was completely still. Then, from the direction of the gallery, I heard a soft sound. I glanced up. In the third row behind the prosecution's table, Diane Whitfield had her hand pressed flat against her sternum. Not crying, not angry, just sitting with the weight of what she was watching, this charade playing out in the same room as her son's name. That image stayed with me through the rest of the afternoon. Drell sat down. Gerald Foss, standby counsel, 12 years of criminal defense, a man who had seen genuinely difficult things in courtrooms, put his face in his hands. The jury watched all of this in silence. Day one was not over. We had 4 more witnesses scheduled, and Marcus Drell still had 41 pages left in his binder. Day 2 of trial began at 8:47 a.m. I knew before I sat down that something had shifted overnight. You develop a sense for it after enough years on the bench, a reading of the room before the room fully assembles. The prosecution team was tighter, more focused. The gallery had grown. Word had spread the way word always spreads in a county courthouse, through clerks and deputies, and the kind of informal network that no journalism school ever documents, but that every judge knows exists. People had heard about day 1. They came to see day 2. Diane Whitfield was in the same seat, third row, navy cardigan again or one just like it. She had brought someone with her this time, a woman about her age, sitting close, their shoulders touching. A sister, I later learned. She had driven 4 hours. Drell came in from the holding area and sat down without being told. That was new. Gerald Foss was already at the table, notepad open, pen ready, with the particular posture of a man who had spent the previous evening making peace with something. I called the room to order, and for approximately 40 minutes it almost looked like a normal trial. The prosecution's second and third witnesses were methodical. A forensic technician who established ballistic evidence. A crime scene analyst who walked the jury through the physical timeline of what happened on that property road. Clean testimony. Professional. The kind that builds a case the way bricklayers build a wall, one layer at a time, each one necessary, none of them dramatic on their own. Drell cross-examined both witnesses. He was, and I want to be precise here, marginally more controlled than day 1. He still challenged jurisdiction. He still referenced common law. He still called the evidence artifacts of a fraudulent corporate proceeding. But he stayed at the defense table. He didn't approach the bench uninvited. He didn't call anyone a fictional state actor. I did not trust it. In my experience, a sovereign citizen defendant who goes quiet is not a sovereign citizen defendant who has reconsidered. He is a sovereign citizen defendant who is loading. I was right. The prosecution's 4th witness was a woman named Patricia Odom. She was the Whitfield family's neighbor, had lived on the adjacent property for 11 years. She had spoken to Caleb Whitfield on the morning of the day he died. She had seen him drive past her mailbox on his way to the property. She had waved. He had waved back. She was on the stand for 20 minutes before her voice began to crack. She described, in answer to Ada Voss's final question, what she had thought when she saw the sheriff's vehicles later that evening heading down the road. She had stood on her porch, she said. She had known the way you sometimes know things before anyone tells you. She had gone inside and called Diane Whitfield's number. Diane hadn't answered. She had called 3 more times. The jury was very still. I was very still. And then Drell stood up, not to object, not to speak. He stood up and in a single, deliberate motion, reached into his binder and produced a multi-page document, stapled at the corner, and held it above his head like he was presenting it to the room. I am placing this court, this jury, and all officers of this proceeding under a common law lien, he announced. Effective immediately. Each member of this jury is hereby noticed that continued participation in this fraudulent proceeding creates personal commercial liability under. The gallery erupted. Not in applause, not in outrage. In the kind of disbelieving noise a crowd makes when something happens that their minds have not yet fully categorized. Patricia Odom on the stand stopped speaking entirely and stared at him. I struck the gavel 3 times, hard. The room came back. Bailiff! I didn't raise my voice, I didn't need to. Remove the defendant from this courtroom. Two bailiffs moved simultaneously. Drell did not fight physically, but he kept talking as they walked him out, still holding the document above his head, still narrating his common law lien into the record, his voice getting louder as the distance between him and the microphone increased, until the heavy door at the back of the courtroom closed behind him and the room was left with only the echo of it. I turned to the jury. 12 faces, some stunned, some angry. One woman in the second seat of the back row, juror number 9, a retired schoolteacher from Valdosta, had her jaw set in a way that told me everything I needed to know about where her deliberations were going to begin. "Ladies and gentlemen," I said, "what you just witnessed has no legal effect whatsoever. A common law lien of the type the defendant described does not exist as a recognized legal instrument in the state of Georgia or in any federal jurisdiction. You are under no liability of any kind. You are jurors performing a civic duty protected by law. Please set what just happened aside completely and focus only on the evidence presented through proper procedure. Can you do that?" 11 nods. Juror number 9 didn't nod. She just looked at me with the expression of a woman who had managed 32 eighth graders for 27 years and was not remotely impressed. Good, I thought. Good. Drell watched the remainder of Day 2's testimony from a closed-circuit monitor in a holding room adjacent to the courtroom. Gerald Foss remained at the defense table, no longer standby counsel in any meaningful sense, just a good attorney sitting in a chair, making sure the record was clean, doing his job in the ruins of someone else's choices. The prosecution rested at 4:18 p.m. I called recess until the following morning, when Drell, if he could maintain basic courtroom decorum, would be permitted to present his defense. I already knew what was in the binder, not the specific pages, but the shape of it. He was going to argue that the land was his by natural law. He was going to argue that Caleb Whitfield was a trespasser on sovereign territory. He was going to argue, and this is the part that never gets easier to sit through, that what he did was not murder, that it was defense of property, that the state had manufactured a crime where no crime under his law existed. He was going to look at Diane Whitfield from across that courtroom, and he was going to make that argument. And I was going to have to let him, because that is what the Constitution requires. And I took an oath to that Constitution 19 years ago, and I have kept it every single day since, even on the days, especially on the days, when keeping it cost something. The jury deliberated for 6 hours and 14 minutes. They came back with a verdict before dinner on Day 4, guilty on all counts. Drell sat completely still when the foreperson read it. No outburst, no declaration, no binder. He sat the way a man sits when the last wall he built has finally come down and the wind is coming through and there is nothing left to hold up. Sentencing was set for 30 days out. That was the day everything changed. 30 days is a long time to sit with a verdict. For the prosecution, it is paperwork and preparation. Sentencing memoranda, recommended guidelines, victim coordination. For the defense, even a pro-se defense built on a foundation of imaginary law, 30 days is supposedly time to reflect, to reconsider, to perhaps finally look at where you are standing and understand how you got there. I have presided over enough sentencing hearings to know that reflection is rarer than people think. What most defendants bring to sentencing is not reflection. It is a revised version of the same story they told at trial, slightly edited now that the jury has rejected it, recalibrated for the new audience of one, me. Marcus Drell brought his binder. The gallery on sentencing day was fuller than it had been at any point during the trial. That is always the case. Trial is procedure. Sentencing is the moment the whole machinery has been building toward. The room knows it. You can feel it in the quality of the silence before the bailiff calls order. Thicker, heavier, like the air before a storm. Diane Whitfield was in her seat, third row. This time she had 4 people with her sister, and 3 others I did not recognize. Family, I assumed. People who had driven distances to be in this room for this hour. She sat straight, both hands folded in her lap. She had a single index card in her right hand, small enough that I almost missed it from the bench. She had written something on it, just a few lines. I would not know what those lines said for another 40 minutes. Drell was brought in from holding. He looked, and I want to choose this word carefully, diminished. Not broken, not remorseful, but smaller somehow than the man who had stood in this courtroom 30 days earlier holding a document above his head and placing the jury under a common law lien. The performance had cost him something, or perhaps the verdict had. Sometimes, when the framework a person has built their entire identity around finally collides with an immovable reality, the collision takes something physical out of them. He sat down. Gerald Foss sat beside him out of professional habit, even though his role had long since become ceremonial. I called the room to order. "Before we proceed to statements," I said, "I understand the defendant has filed a pre-sentencing motion." Drell straightened. Some of the old energy returned to his posture. "I have filed a motion to arrest judgment on the grounds that this court lacked subject matter jurisdiction throughout these proceedings, and that the verdict is therefore legally void under." "The motion is denied," I said. "It is the 14th jurisdictional challenge filed in this case. The answer has been the same each time and will not change. Jurisdiction was established at arraignment and has been affirmed at every subsequent stage of this proceeding. We will move to sentencing." He looked at me. "Mr. Drell," I said, and my voice was, I want to be honest here, not unkind. "I need you to hear me right now. Not as a sovereign man, not as a flesh and blood person operating under common law. As a human being sitting in a chair. This is the last time this court will address you before I impose sentence. Whatever you believe about the law, whatever framework you have spent years constructing, none of it is going to change what happens in the next hour. I am asking you to be present for it. Genuinely present. Can you do that?" He said nothing. I took that as the closest thing to yes I was going to get. Ada Voss delivered the prosecution's sentencing recommendation. Life imprisonment, no possibility of parole. She walked through the aggravating factors methodically. The premeditated nature of the confrontation, the defendant's prior civil history with the victim's family, the fact that Caleb Whitfield was unarmed, posed no physical threat, and was performing a lawful act on property the defendant had no legal claim to. She was precise and she was thorough, and she sat down in 4 minutes flat. Then I turned to the gallery. "At this time," I said, "the court will hear from the victim's family. Miss Whitfield, Diane Whitfield, you have indicated a desire to address the court. You may come forward." The room shifted, not loudly, just shifted. The way a room does when the person everyone has been watching from a distance finally stands up and moves toward the center of it. She was small. I had noticed that from the bench during the trial, but it struck me again now, the physical smallness of her, walking from the third row to the microphone that had been set up at the podium between the two tables. She moved slowly, but she moved steadily. She did not look at me when she reached the podium. She looked at the index card in her hand, then she looked up. At him, not at me, not at the gallery. Not at Ada Voss or Gerald Foss or the court reporter or any of the 14 other people in that room. Directly at Marcus Drell. And he, for reasons I have thought about many times since, did not look away. For the first time in the entire proceeding, he held eye contact with another human being without defiance or performance or the careful blankness of a man managing a strategy. He just looked at her. She spoke for 4 minutes and 30 seconds. I know because the court reporter's timestamp is in the record. In those 4 minutes and 30 seconds, she described her son, not his death, her son. She described the Sunday phone calls. She described the way he laughed, said it started in his shoulders before it reached his face, that you could always see it coming. She described a fishing trip they had taken the summer before he died, just the two of them, and how they had caught nothing and talked for 6 hours, and she said it was one of the best days of her life. She said she had spent 30 days trying to decide what to say in this room. She said she had written many versions. She looked at the index card once. Then she set it down on the podium and did not look at it again. "I want you to know," she said to Marcus Drell in a voice that was quiet and clear and did not waver, "that my son would not want me to come in here full of hate. He was not built that way. I am trying very hard not to be built that way either." She paused, drew one breath. "I forgive you. I pray you find peace." 7 words. I have described the silence that followed to people who were not in that room, and I have never quite captured it. It was not the silence of shock, exactly. It was the silence of a room full of people suddenly confronted with something they were not prepared for, something that did not fit the expected shape of what a sentencing hearing is supposed to sound and feel like. Drell did not move. For a long moment, I counted 5 full seconds, he sat completely still, and something moved across his face that I had not seen there at any point in the preceding weeks. I am not going to name it because I am a judge and not a psychiatrist, and I did not know this man's interior life. But it was something real, something that had nothing to do with jurisdiction or common law or 47 pages in a color-coded binder. Diane Whitfield returned to her seat. I waited a moment before I spoke. The room needed that moment. Then I imposed sentence. Life imprisonment. No parole. In accordance with Georgia law, in accordance with the jury's verdict, in accordance with 19 years of obligations I took on the day I put on this robe. Marcus Drell would spend the remainder of his natural life in a Georgia State Correctional Facility. He would not walk out of a courthouse again as a free man. He was still sitting quietly when the bailiffs came for him. No declaration. No binder raised above his head. No final jurisdictional challenge for the record. He stood when they asked him to stand. He walked when they led him to the door. At the threshold, and I want to be careful here because I am telling you what I observed from the bench, not what I concluded from it, he stopped. Just for a second. He did not turn around. He did not say anything. He just stood in the doorway for one breath longer than was necessary. Then he was gone. I have been asked what I think about cases like this one, about sovereign citizens, about men who build elaborate ideological structures to avoid accountability, about what drives a person so far into a framework of self-declared exceptionalism that they genuinely arrive, in their own mind, at the conclusion that the law does not reach them. Here is what I think. I think the law is not a building you can opt out of by filing the right paperwork. It is not a contract you can revoke. It is not a corporate fiction or a maritime jurisdiction or a colorable title. It is the architecture of a society that has decided, collectively and imperfectly, and at great historical cost, that no person is above accountability for what they do to another person. Caleb Whitfield was 24 years old. He waved at his neighbor from his truck window on a Tuesday morning, and he never came home. That is the fact at the center of everything. Every motion, every outburst, every jurisdictional challenge, every page of that binder, none of it changes that fact. None of it was ever going to change that fact. The law understood that, even when the man who pulled the trigger didn't. And Diane Whitfield, a woman who lost her son to a man who believed the law had no claim on him, walked into that courtroom and offered him something the law was never designed to give and never could. That is not justice, exactly. That is something beyond it. I have been a judge for 19 years. I will carry that woman's 7 words for the rest of my life. Court